Good afternoon. I'm Payam Akhavan at the McGill University Faculty of Law, and I'm delighted today to be chairing this fourth dialogue on perspectives on criminal justice, which will be the fourth in the series of dialogues celebrating the 10th anniversary of the Center for Human Rights and Legal Pluralism. I'm pleased to be joined today by my two esteemed colleagues, both specialists in criminal justice, Professor Alana Klein to my far right, and Professor Maria Manikis, and we will be speaking today about a broad range of issues relating to criminal justice. Welcome, Alana and Marie.
Thank you.
And the first thought that comes to mind is that criminal justice is a rather grim subject. We are dealing with violence and human depravity. So the question I want to begin with is, what is it that attracted you to this particular area of research and scholarship? Perhaps you can start, Alana.
Okay. So when I started studying law here at the faculty, you may not be surprised to know that my interest was in international human rights. And I came into the faculty with that hope, as do many students who come to our faculty. And it's interesting to me that I am back talking about human rights again here in this discussion in a way. But I viewed my interest in criminal law in a way as a bit of a detour from that. So I studied, when I came to study at the Faculty of Law, I was really interested in my criminal law courses. And I was interested in them particularly because of what I looked at as this really curious and idiosyncratic way in which they dealt with human experience. And that's true in some ways of lots of my classes, but I found in criminal law it was especially striking to me. But it was an interest that I sort of put aside, and I remember my first summer after I started studying law, I went and worked in a program designed to integrate law students into Palestinian-Israeli reconciliation. And so I went and worked for the Palestinian Ministry of Economy and Trade. And there I became especially interested, and I'm coming back to criminal justice, I promise, but there I became very interested in how, I had grown up in a very Zionist family. It was labor Zionist, it was lefty, it was feminist, but it was Zionist. And I was struck when I went to go work, I was working in Ramallah that summer in Palestine, and I was struck by how different the narrative was. And of course I was anticipating it being different, and I knew it was going to be different, but the emotional impact of the difference in the narrative that I heard while I was living in Ramallah and the narrative that I heard growing up about the region was so striking and had a strong emotional impact on me that it sort of stirred up my interest in criminal justice and the different narratives of experience. And so that's sort of the roundabout way. And the summer after that I came to be interested in going back to criminal justice. Well, the summer after that, I worked at an organization called the Canadian HIV/AIDS Legal Network, who I've continued to work with to this day. It's had a profound impact on my life as well. And that organization was working on poor and marginalized groups, in particular people who are affected by HIV/AIDS. And there I begun to notice the extent to which criminalized populations were vulnerable to HIV, and also the way that HIV made those populations vulnerable to coercion from the law as well. And so that's really what sparked my interest, and one of the main areas of research that I work on now, drawing from that, is criminalization of HIV transmission and exposure. That's been one big area of research for me, and different perspectives on criminalization of HIV transmission and exposure, which has allowed me, and I think we'll talk about that in this discussion, to really engage with how different perspectives view a phenomenon like criminalization. So,
thank you. Marie, what about yourself? What
it's a fascinating experience. What got me into issues of criminal justice was I was basically reading a lot of John Grisham books. So this is one of the starting point to the world of different racial concerns and discriminations that exist. So from a very young age, I was very attuned to these realities, but through just reading literary fictional books. And then I decided to go into law school and ended up taking some courses on criminal law, criminal justice, writing papers about the experience of sexual assault complainants in the process, as well as people who have been excluded from that participatory element. And I just became more and more interested. I decided to go into practice for some time. And I actually I worked for a bigger law firm as well as a smaller firm that did some criminal law. And I ended up seeing the disparity as well in the resources that some law firms have versus other smaller law firms, and how the representation of clients varied greatly between the two. So issues of access to justice, also participation in the process, as well as who gets heard and who doesn't, are areas that have been fascinating me, and I've continued my research ever since. I've also represented some victims who were claiming to and wanted to receive compensation in administrative tribunals. So that had a different perspective in the system, and basically everything we know about criminal justice. Also, there's other systems that operate as well, and it was an interesting way to see how different systems actually look at the same specific issue or specific conflict. And so basically these are elements that actually inform my research and continue to do so.
Well, in answering the question, both of you immediately reflected on your personal experiences, your practical experiences in a sense. So perhaps before going to the second question, there is a broader issue here about the nature of scholarship. We speak about scholarly knowledge, and one of the assumptions is that we privilege objectivity over subjectivity, abstractions over intimacy, and in a sense you began with what were quite intimate narratives of how you have experienced criminal justice. So how do you reconcile those very idiosyncratic experiences with the greater intellectual enterprise, which is all about coherent theoretical frameworks? How can one reconcile the two, and is it actually possible to have one without the other?
I think one of the reasons that I was interested into actually pursuing an academic career and looking at the research front is precisely because it allows me to step back from the day-to-day elements of criminal justice. So instead of solely focusing on one personal anecdotal experience, looking at the criminal justice from one step back and seeing the different systemic issues that actually take place. So through my research, I've tried to, and I think that's one of the greatest things, is to build up on research that's already out there. So, looking at what are the elements or the problematic elements of the criminal justice system, and try to, take one step back and contribute to that conversation. So I don't see it as, kind of a subjective way. And I think these experiences allowed to see some reality that existed, and use this reality to inform some of my research and look at it through, a broader lens, theoretically, and also through empirical work.
Yeah, I mean, I would say that I haven't chosen to approach my scholarship from this kind of objective perspective in some way, which may be to my detriment in some ways. But I feel like it's something that I hold in common often with my students, right? Which is, this is what struck me when I talk about my criminal law courses. What struck me is that there was this seemingly objective narrative about what was going on that was so discordant in my own experiences with the subjective appreciation of what was happening. And I think that in a way, we're bringing some more subjective experience. This is, after all, the Center for Human Rights and Legal Pluralism. And I think so much of human rights and so much of legal pluralism is about integrating, not just, I wouldn't even say integrating those subjective experiences into an objective account, but finding ways for those subjective experiences to dialogue in recognition of multiple accounts, none of which is purely and wholly objective. And I think that's a lot of what I've worked on in my criminal law courses, and I see my students here in the room today, is showing that these seemingly objective, rational accounts of what criminal justice is doing deserve to be questioned. And so I encourage everyone to think about their approach to criminal justice from a subjective perspective, but also one, of course, that listens to other people's subjective perspectives, but that perhaps rejects this notion of a coherent, neutral account of what criminal justice is or does.
Speaking about subjective perspectives, obviously, in every criminal trial, there is an accused person, and then there is a complainant. And I suppose in the case of conviction, there is the perpetrator, and there is the victim. So when you speak about different perspectives, I'm trying to understand how it is that we're addressing the topic of criminal justice in a series focused on human rights. How is it that you frame criminal justice as a human rights issue? Is it the human rights of the victims? Is it the human rights of the accused to a fair trial? Why is it that we would frame criminal justice as a question for human rights to begin with?
I mean, I think the notion of rights in criminal justice traditionally have been conceived quite narrowly. Rights of an accused, for example, and I feel like that narrow definition of what rights are that you see in traditional criminal justice is in many ways discordant from this very broad and robust notion of rights that you see in international human rights. So in international human rights, you learn that there are civil, political, social, economic, cultural rights, group rights, individual rights, and those rights are indivisible and interdependent, and we hear this language in international human rights, whether you know, we can be critical of that language as well, but you don't even see that in criminal justice. In criminal justice, well, I mean, I think we do increasingly, I think in many ways, as we engage with the effects and impacts of criminal justice on Aboriginal people, on Black people in Canada, and even in many ways in recent weeks we've been talking about the impacts of criminal justice for women. We've been recognizing that these narrow conceptions of rights that we've seen traditionally in criminal law really don't encompass or reflect the rights impacts of criminal justice. One particular area of interest of mine is health. And the relationship between criminal justice and health. And the health impacts of criminal justice, you probably will not be surprised to hear that, you know, the application of the criminal law is generally not especially good for one's health. Arguably, it's good for the health of the population. I would maybe dispute that. But certainly for people who are implicated in the criminal justice system, the health implications can be quite serious. And we've seen this in, for example, regulation of sex work, legal criminal regulation of sex work, which has put the lives and safety of sex workers at risk. I see this in my own research that I do on criminalization of HIV transmission and exposure. And looking through this sort of narrow conception of rights as you've seen within the traditional confines of the criminal law, I think fails to reflect that. I think the criminal law is getting better at, in many ways, reflecting that broader conception of rights that we see in human rights. But there's a long way to go, and I think we still have a lot of work to do.
Very good. And maybe I can ask you one last question on this theme. Since we're looking at the relationship between criminal justice and human rights law, and in particular international human rights law, much of the jurisprudence on criminal justice in the Supreme Court is charter litigation, charter-based challenges to criminal laws. And in particular, we have challenges based on principles of fundamental justice under Section 7, which are very frequently interpreted in light of international human rights law. So how do you see in that context the relationship between criminal law and the jurisprudence of the courts on the one hand, and the way in which international human rights standards are shaping the Canadian discourse? And is this a good or a bad thing? Do international laws which are intended to apply in widely divergent societies with very different cultural and historical contexts, do they really adequately reflect a uniquely Canadian perspective on criminal justice?
That's a really interesting question. Even the uniquely Canadian perspective is an interesting way to formulate it. I mean, what is a Canadian perspective to start with? I mean, there's different views, there's different...
It's my perspective.
I could imagine. So I think it's actually using the international law principles to inform what goes on in the Canadian approach is actually very helpful in trying to open up the minds of and getting a bit more some plurality of views within that process, as well as you know, as Alana was saying, it's very much focused on this kind of individualized conception of human rights, and it's still very much the prevalent way that these rights have been conceptualized. So one of the, you know, this one thing that we could learn might be to get, you know, what about community rights, or even, you know, seeing it as more social rights. And it seems that, as Alana, I totally agree with you, you know, it becomes a process where it's quite limited. The discussion is very slow to start. We hear about equality elements and claims, but very much, very tossed off in the process. And when they do happen, there's kind of a fear, maybe it's just that the system is built that way, that since we're there to determine whether this person is guilty, and then focusing very much on this one individual, it's very difficult to bring other perspectives. I think there's, and I think there is space for that. If you do look at what's happening in sentencing, especially, it seems like there's more room, or at least a greater will to include systemic issues, putting the state on trial to some degree. When we look at the state abuses being considered as a mitigating factor, I think that's kind of an opening to saying, well, we're not just focusing on this individual and the individual rights of this specific person, but also how the system has played out, and what are the issues of responsibility that also are focused on the greater system.
Maybe you can elaborate on systemic abuse for our audience. What exactly do you have in mind?
So,
authoritarian states with systematic human rights violations, for example.
Well, what I mean is, for example, if a police officer, for example, or a State Department has breached an individual's rights in the process, these could actually be questioned and brought forward in the sentencing stage, and this could be used to mitigate a sentence effectively. So if you are to use this, it's interesting because it's the state that is prosecuting the individual, but at the same time, that state might lose its legitimacy to do so and to actually punish an individual when they're also part of this greater issue, or have contributed to some of this, to this reality and to this systematic abuse against an individual. So I wonder how far that's going to go. I mean, right now we're really focused on specific types of abuses. I wonder to what extent can we actually talk a lot about race and discrimination. There is there's a will for courts to actually include and look at Aboriginal background, for instance, or indigenous perspectives, and why have these individuals been brought to a court. And in that respect, it seems that there's this desire to engage with that, but at the same time, the criminal process being limited in what it can do. And we will probably address issues of restorative justice, which we will talk about a bit further, I believe. So,
very good. Well, moving on, and perhaps you can start this next round of questions. In my criminal law class, I begin by assigning to students Michel Foucault's Discipline and Punish, and there are these gruesome scenes of the rituals of torture which took place in the streets of Europe until the late 18th and early 19th century, before the modern reforms which led to contemporary conceptions of criminal justice. And of course, we look back at the so-called lex talionis, the law of retaliation, with horror. We believe we have a very humane, advanced criminal justice system. Retribution still has a role to play, but we emphasize utilitarian justifications, the harm principle, a very important concept in Canadian jurisprudence. So I want to perhaps ask you, well, why do we punish? Because criminal justice ultimately is about punishment. It's what distinguishes criminal justice from other branches of the law, at least to the layperson, from the superficial perspective. So why do we punish? Is retribution still a form of vengeance, perhaps a more sophisticated, humane form of vengeance, but still a way of exacting revenge for wrongdoing? And when we talk about deterrence, is deterrence realistic? This sort of mechanistic idea based on Jeremy Bentham's conception of the rational cost-benefit calculator, that the criminal rationally calculates the costs and benefits of crime. And I mean, are any of these rationalizations for criminal justice sensible? And if not, then why do we punish? What is criminal justice really all about?
That's a very complex question, and I will start by saying that the notion of punishment probably varies depending on, on cultures, on the rationales behind the rationales why we punish will probably vary from tradition to tradition. So in Canada, or in the common law world, it seems that there's this, as you alluded in your answer, we punish for retributive purposes. So some would say it's a way to censure some forms of conduct, using von Hirsch's terms of censoring, or also to communicate a message to the population, as Duff would term it, in more of these communicative functions. So we realize that there are some conducts that in society we do not agree with or do not accept, so kind of a moral, or, and there are different theories behind that. And we decide, because of that, we need to communicate a message that we will not accept these kind of conducts. At the same time, there's other theories that have been developing, as you say, the utilitarian approach, where we don't just punish for punishment, but we also want to achieve a greater purpose with what we do. One of them being rehabilitation as a possibility for punishing, deterrence, as you mentioned. Whether they work or not, some empirical studies, just referring to Anthony Dube and a few other criminologists that have looked at the issue of deterrence, whether we're looking at specific or general deterrence, doesn't seem to be very much working. So again, the notion that
What is the difference between specific and general deterrence? So, perhaps you can explain.
Specific deterrence is basically, I'm punishing you as an individual and you're going to change your actions based on that punishment. So, very much focused on the individual before us. General deterrence is basically for the general population to view that, this person has been punished, so let's use this person as an example and you will change your conduct based on the punishment that this person has received. So general is more based on, how the public will perceive this and how they will change their actions. It very much is premised on the foundation of criminal law, which is really, you are rational agents, you have committed an offense because you've actually, calculated this, you had a mental process to do this, and therefore, in order to dissuade you in any way of continuing, this punishment will have that effect. And that's where the studies come and show us that actually that's not really how it works. There's probably much more complex issues or reasons why people end up committing offenses, and having this discourse about how this punishment or increase of punishment could magically change behaviors is completely unrealistic. And interestingly, the courts have realized this. I'm just referring to some cases on mandatory minimums. They've, highlighted that deterrence doesn't really seem to work, and they've included empirical work suggesting that, that doesn't work. So the question is, why are we still using that term? Why is it still present? There's, again, probably more political ways, or, again, how do you communicate with the public? And, it seems like there's a political agenda to get some forms of points based on how punitive you are. Hopefully, with a more, by informing the public, informing everyone, we might think differently, as well as what works and what doesn't, and really thinking about the causes of criminal law, or the causes of criminality. We might stir away from this actual objective of punishment.
So Alana, if many of the past myths about the purposes of punishment have proven to be untrue, why, in your view, do we still punish?
I think the reasons are historical, cultural, and political, and you alluded to some of the history, and I think Marie explained very well some of the political reasons and some of the cultural reasons. We do it because this is what we've been doing, and so we continue to do it. It continues to be a response to behaviors that for some reason our legislator, which of course is affected by, in various ways, by our populace, has decided to respond to these kinds of issues. It's largely historical. It's what we've been doing. And I agree that in a lot of ways, much of the study of criminal law is trying to dig up what's really going on there, right? Why are we punishing for these particular kinds of behaviors? What does it reflect about us as a society? What does it reflect about our history as it's been filtered through these institutions? So, for example, again, to go back to HIV non-disclosure, if you ask a social worker, a nurse, what's HIV non-disclosure about? So for those in the room who may not know, and those in the audience who may not know, in Canada, failure to disclose one's HIV status to a sex partner is a criminal offense that can result in conviction for sexual assault on the basis that that failure to disclose constitutes a fraud that cancels out, or in legal terms, vitiates the consent to sex. So long as, and this has been developed through jurisprudence, but so long as there's a sufficiently high risk, which is not in fact, very high risk, even what the Supreme Court has called a realistic possibility of transmission, which has in fact been defined as a very low risk, has been criminalized. So if you ask a nurse, as I began suggesting, or if you ask a social worker, will this deter? The answer will be, well, look, our understandings of what are obstacles to disclosure of one's HIV status in the context of sex is not that people don't think they should be disclosing. That's not that they think that most of the time people think, in fact, and the research has borne this out, that it's a good idea to disclose, and not only a good idea, but really a moral responsibility. Right? So the criminal law is not really necessary to deter, and in fact, there's really very little evidence, in line with what Marie has been describing, that actually works at all. And I think a better theory to explain that, and so in a way I look at these questions of why we punish almost as a way for us to understand what criminal justice is doing. Better way to explain that, I think, might be some of the communicative or retributive functions or denunciatory functions that Marie was discussing as well. But when you plumb those, I think that's where you get to see what a specific perspective those functions are deployed through. And so, for example, the idea that it's the person who is HIV positive who's got the power, who is in possession of the information in a particular sexual interaction is called into question, for example, when you understand that some of the reasons why people might not disclose have to do with things like fear of abuse, fear of economic rejection, fear of being abandoned, for example. And that these are some of the reasons why people fail to disclose. And in that context, this notion of retribution as though someone is committing a moral wrong really depends on which perspective you're looking at the problem from. And so I think, to go back to your original question, why do we have these ideas? I think these are ideas that we use in order to try to be able to understand this phenomenon. But in fact, the phenomenon is as complex as our societal perceptions of HIV and reflects our prejudices about, for example, something like HIV. People regularly consent, for example, to have unprotected sex that carries a risk of transmission. And yet, in the context of HIV, it's almost as though our courts and our society have refused to recognize this assumption of risk, right? So it's a desire, I think, it reflects a desire to lay blame for risk, and in some contexts, like in this one, and to sort of give us a semblance or a sense of control over things that go wrong in our society in some way.
Thank you. Maybe one last question on this topic. I'm reminded of the writings of the Norwegian criminologist Johs Andenæs, who speaks about general prevention as a flow of moral propaganda from the criminal justice system, what he calls the socio-pedagogical influence of the criminal justice system in instilling subliminal inhibitions against crime. So he sees the criminal justice process as part of a process of socialization and internalization of certain norms. So if we see criminal justice in that wider social context, does it make sense to address problems through criminal justice when a problem is not a form of deviance, but actually a habitual norm in society. The foundation of a criminal justice system is habitual lawfulness. The criminal justice system can address problems successfully because criminals are at the margins of social norms. But, for example, the question of sexual assault. We all know that there is a gross underreporting to the tune of, I believe, 96%, according to Statistics Canada from some years ago, and that even from the very few cases that are reported, an even smaller number are actually prosecuted, and a yet smaller number results in convictions. So how important is the criminal justice process in, for example, dealing with an issue like sexual assault, which is not really a form of deviance when one looks at the actual conduct of society, but which is actually a widespread practice? How does one understand the relationship between criminal justice and wider social processes that need to take place to address these sort of evils in our midst?
Well, I think just focusing everything in the criminal justice process is going to fail. There's no. We need to look at other systems that also exist and that could actually tackle some of the issues that are reproduced and happen in the criminal justice system. If we are to think, for example, as something as prevalent as sexual assault, or something as prevalent as people who steal, or if we tend to think that it's a marginalized thing that happens, but in reality, when you look at statistics, it's actually much more common. So perhaps one of the ways to think about this is to through education or through other systems that might preserve a more equality way of thinking. Obviously, if society thinks in a specific way, the same issues are going to be reproduced at the criminal justice process. So, if there are myths and stereotypes, or if there are, ways of conceiving the criminal or complainants or within, the wider society, chances are that this is going to be reproduced also at the criminal process. So I think there's much work to be done, much before even reaching the criminal justice process, in terms of, getting people to talk about these issues and also to explain what it is, and trying to work on these power imbalances that actually exist in our society, and work towards that instead.
So the next question, Alana, which really I think follows very well from this discussion, is the question of restorative justice, and more specifically, restorative justice as practiced in Indigenous communities. And the Truth and Reconciliation Commission in Canada, of course, includes among its many recommendations greater use of sentencing circles and restorative justice. So how would you contrast that conception of justice from the retributive model, which is embraced by, if you like, mainstream culture in Canada? So in what way is restorative justice different, and what do we have to learn from restorative justice? Is this a kind of practice which applies in tightly knit communities based on kinship, or could we learn to apply those same concepts in non-Indigenous context in Canadian society?
Well, that's a big question. And to me, when I hear that question, it raises sort of two questions from my perspective. The first question is, why is it useful or important to have plural conceptions of criminal justice more broadly? So that's not specifically related to Indigenous justice in particular, but plural conceptions of justice that would welcome something like restorative justice. So why is it important to make space for example, restorative justice within our criminal justice system? And then the second point, and you mentioned the Truth and Reconciliation report, is I think about how badly our criminal justice system has failed our Indigenous people. Marie had mentioned before the over-incarceration of Aboriginal people in Canada, the attempts to address this over-incarceration through sentence.
I understand that is by over-representation by a factor of 10 to 1.
Yes. Yeah, and not only that, but since we've tried, since the courts have tried to address this through sentencing, overrepresentation, excuse me, has actually gotten worse, right? And to me, what that reflects is really the difficulty of trying to deal with this only at the sentencing stage, which is exactly what Marie had talked about as well, but the difficulty of dealing with this at the sentencing stage when our entire system of criminal justice has this really substantial disjuncture with the way that justice is understood and practiced in different communities. There's, of course, no one conception of what restorative justice is. There's no one conception of what Aboriginal justice is. Aboriginal justice need not necessarily always be in line with different conceptions of restorative justice. But I think that what's clear is that the state-based traditional criminal justice system that we have been employing here in Canada is a very poor fit in multiple ways with many Aboriginal conceptions of justice. And so,
well, how do they differ? What do we mean when we talk about restorative justice? How would you describe it?
Right. So restorative justice focuses on, and this is the Truth and Reconciliation Report describes restorative justice in these kinds of terms, or describes Aboriginal conceptions of justice in healing terms, right? So the focus is on healing relationships, right? That's the primary goal, is to heal relationships. And as you suggested, maybe that's something that works within tightly knit communities better than it does within more dispersed communities. There's been a lot of controversy even within Aboriginal communities about the use of restorative justice, particularly for certain kinds of offenses where even, for example, for sexual assault, where Aboriginal feminist women have actually been very divided about whether they think restorative justice processes that focuses less on finding out what the truth is and punishing, which is what our prevailing system of justice does, and instead on repairing, can work in contexts where there's such often a great power imbalance, gender imbalance between men and women in contemporary society. So the discussion of restorative justice, to me, raises this question of, well, why is our criminal justice system such a poor fit with so many Aboriginal communities? And before arriving here, I was reading Rupert Ross, which I know a number of you in the room have read, and this was a Crown prosecutor who went and wrote a number of books reflecting on his experience as a Crown prosecutor and the disjuncture, essentially, between Canadian conception of justice and the conceptions of justice that he saw in the Aboriginal communities in which he worked. So he worked in a number of northern Aboriginal communities in Canada, and then later continued to engage with those communities. He talked about, I teach evidence law, so the law of evidence is focused on getting at the truth, right? You get at the truth through typically witness testimony. So witnesses come in, they tell you what happened, they tell you what to believe. If you believe those witnesses, then you find out that A, B, or C, criminal offense has been committed. You've reached that point of guilt or not guilt based on that testimony, and then you punish. And it's only when you've proved guilt beyond a reasonable doubt, which is of course a very high standard, that sanctions will then come to kick in. Well, what Rupert Ross discovered was that the ways in which the people in the Aboriginal community that he visited communicated were often reluctant to posit absolute truths and to say, you must believe me. But rather, they were much more oriented towards expressions of this is my experience, you take of that what you will. Right? This doesn't always play well in a traditional court system. If the focus is on healing, then it's much more, this is my experience, you audience, or you person who's listening to my experience, take from that what is useful for you. That's something that's more consistent with Aboriginal traditions of healing, for example. But it's very complicated, right? So that's why I say it's not enough, it's very complicated in the sense that everyone within the process, in order for that kind of communication to bring about harmony, has to be in the same frame of mind. And so when an Aboriginal person comes in and doesn't conform to our court system's expectations of what a witness is going to say, of the certainty with which a witness is going to present truth and not truth, we see under-enforcement of criminal law for Aboriginal complainants, for example, and over-incarceration of Aboriginal accused, right? So the system is not serving Aboriginal people. Now, then your question was, well, what do we have as a Canadian society to learn from that? Well, I think that if we look around, we see that in fact, our Canadian system of justice is not serving a lot of people. A lot of people come through the criminal justice system and find that what it's proposing doesn't resonate or isn't relevant with them. One of the big lessons of pluralism is that we need to look at the lived experience of people to understand what laws are actually governing their relationships, and to ensure that, to work to ensure that whatever legal frameworks are affecting them in various ways, whether they be state-based or not state-based, be attuned to their experiences, right? Be responsive to their experiences and their expectations. And so I think what traditions of restorative justice can offer us is an opportunity to ask ourselves, what do we expect as a community or as different communities from our criminal justice system? If in fact we say this is about rehabilitation, or it's about restoring relationships in some way, it's about restoring balance, well, maybe Aboriginal traditions have a lot to teach us about how we might do that. And maybe restorative traditions have a lot to teach us about how we might do that.
Perhaps following Alana's comments, Maria, I can ask you, what was intriguing by Alana talking about legal pluralism in a sense as multiple conceptions of justice, which of course is very appealing. We are, after all, at McGill. We believe in legal pluralism. But I want to perhaps ask a somewhat provocative question. We live in a multicultural society. Perhaps Indigenous peoples have a special place in Canadian history and Canadian society. But if we look more broadly at the application of restorative justice in a multicultural society in which there are multiple communities, which to the extent that there are also tightly knit, cohesive communities, could have their own conceptions of justice, how far can we take the idea that we can fragment the criminal justice system into all these lived experiences? Does criminal justice not require coherence and predictability? Does it not have to treat similarly situated people similarly?
That's a great question. I mean, that's the complexity of this world, is that not everybody is similar, and there's very different legal norms that operate. If we look at, for example, even the concept of restorative justice and how it's actually, even when we try to have initiatives of restorative justice within the criminal process, it's still state-driven. It's still the norms that operate that process is still very much linked. There's evaluation elements, and there's things that are linked with the actual state-run process. So we might need to include, or actually be open to the idea that other legal norms may exist in other settings, and the idea of self-governance for some Indigenous, or for Indigenous populations, might be that instead of being a state-driven model that operates within these communities, perhaps there's their own laws exist, their own traditions, and that might be one way that's much more realistic. If you read, there's some interesting work by Val Napoleon, who has looked at restorative justice mechanisms and how they exist, particularly in the Nakota community in Alberta, and has seen that what happens is it's often a state-driven, I mean, it is implemented by the state in these communities, but the process itself still moves around and is driven by Indigenous conceptions of justice. So they operate at a non-formal level, but they're still very present. For example, if an elder is present or a member of the community, what happens in the restorative justice process doesn't just stay at that formal process. Sometimes, for example, a member of the community will go and visit the youth that's been offending. So there's a process that goes on outside of that main forum. So and where it's based on the issue of or the principle of kinship, and there's different family ties that exist, and that's going out, not just strictly based on the formal mechanism in place. So there's different ways that these restorative justice processes could operate, and they do operate even when there's a more legal state-driven framework. We could still see these other ways of normative operation. So I think that even in many of the state-driven processes, we might see things that happen outside of, let's say, the courtroom. We might see, for example, plea bargaining. All of these things happen and are a reality where people get together and start talking. Obviously, who has powers and to what extent can that fit into the but I think there's a lot of these things that are already operating. We might just want to be more open to the idea that certain communities might have different visions or might have different traditions that might not fit exactly well or might not be accommodated or effectively by these processes.
Yeah, can I add something? I mean, I don't find that our system as we currently have it actually treats similar situations similarly, right? That's part of the challenge, right? It's the access to, in a way you can frame it as an access to justice challenge in criminal law, but there are certain circumstances where people are believed and certain circumstances where they're not believed, right? And so, for example, and those are driven by stereotypes. And we saw that this week, or last week, I suppose it was, in the Jian Ghomeshi verdict, where, purportedly applying neutral principles of credibility, for example, the judge said, well, and of course it was very well publicized and everybody in the room has been talking about it a lot, but there were some inconsistencies that the judge recognized in some of the testimony of the complainants. But beyond that, the judge went on, in my view, to apply certain stereotypes about, for example, what is considered sort of plausible post-assault behavior. And in the judge's view, for example, the women continuing to have sexual relationships with an assailant or email relationships with an assailant after an alleged assault, for him called into question the credibility, that fact, not just the fact of inconsistencies, but the fact of the continued relationship, called into question the credibility of those complainants about that initial assault. To me, this reflects applying a purportedly neutral concept like credibility in a way that is not in the slightest bit neutral, right? And so in a way, you need a more plural conception of normativity in order to be able to understand that not everyone is going to follow the paradigm that of behavior that a particular trier of fact might expect.
So in a sense, pluralism is the path to equality.
Well, without the path to equality is complicated, but without understanding plural conceptions or different communities' conceptions of what qualifies as plausible behavior or quote-unquote normal behavior, the criminal justice system is going to continue to discriminate. And so, for example, the point that I raised earlier about the credibility of Aboriginal witnesses being viewed more negatively in light of Aboriginal modes and forms of expression, which make perfect sense and are perfectly appropriate within Aboriginal context, without recognizing that sort of culture clash, in a way without recognizing the important normativity of that other social order that says, you don't tell other people what to think, you're not going to be able to understand A, what's being communicated in a courtroom, but B, maybe our courtroom process that's focused as it is on truth on finding truth doesn't necessarily make sense. Now, we talked about why do we do this in the first place, and I said, look, this is an entrenched system that we've got, right? There's a certain path dependency. It's very hard to get away from that path dependency. But I think it's important to recognize the weaknesses of a system that's based on arriving at a truth through testimony in that way, and to recognize that it systematically devalues other forms of narrative.
And the question I would ask as a follow-up is, well, what do we replace the system with? What system would be better capable of reflecting these plural voices and experience and context? Does it have to do with having diversity among the judiciary? Is that going to solve the problem? What practically can we do?
Yeah. I mean, this is a question, you know, and Marie, you can weigh in on this if you want to, but for me, it's a question of what Marie raised earlier, which is societal change at the same time as we have legal change. I mean, legal systems change gradually. It's very unlikely that we're going to, although, you know, it might be a good idea in the abstract, say, you know what, our system of arriving at truths and then punishing based on truths systematically discriminate against certain populations. They systematically discriminate against women, they systematically discriminate against Aboriginal people, and therefore we're going to abandon them and replace them with another form of justice. I think that that's unlikely. But I think that you know, this Ghomeshi decision has resulted in a lot of conversation, some of which I think has been more productive than others, about, for example, you know, normal post-assault behavior, and has made some efforts toward removing some of those stereotypes. Okay. So I think in a way there's space for adjusting the existing system that we have. It has its limitations, but there is space for that. But there's also, I think, room for moving some of the important questions outside of the focus on the trial itself, right? And the notion that the trial is the place where we as a society come together and determine, you know, how we're going to create our history and how we're going to respond to that history is something that we can move away from. And so, for example, there's been a focus, you know, on policing and police practices, right? I think that focus on policing and police practices represents a recognition that the justice, the center of where justice, quote unquote, whether it's good justice or bad justice or the appropriate justice is done, doesn't necessarily come at the place of the trial, right? It comes at all of the places in which various actors in our society engage to impose ideas of justice. That can happen at the policing stage, that can happen in a family, right? And that we need to be attending to those places. So for example, you know, someone who's been sexually assaulted might first disclose to a family member. Well, that family member needs to be equipped to hear that person.
And just to add to this, I think this is completely, you know, it makes sense to shift away from the trial itself. And that's one of the elements that we keep on looking at is what happens at the trial. But much of the earlier decisions take place before, even from the moment somebody gets stopped on the street, who gets stopped for what reason and what information is collected from this individual. That has a huge impact. And so I think we might need to also make, it's very much institutional mind frame shifts. That's what we really need to be doing. So instead of, you know, just looking at the laws and, you know, what kind of laws are in place, or even human rights, and looking at the charter and what rights are in place, it's really what happens as, you know, some criminologists would say, the blue letter law. In other words, how police create these different norms of operation, as well as prosecutors, and how these actors could become agents of plurality, if we think of it, if their function is taken in that sense. So instead of strictly being driven by crime control or, you know, another model that has been predominantly taking place in our society, if they actually think about their role, for example, prosecutors as ministers of justice that actually need to engage and take into account the reality of indigenous populations and see who gets more prosecuted in the wider systemic sense. You know, that time and again, statistics show that indigenous and people, you know, from visible minorities are much more detained, or even, you know, and actually prosecuted for similar, or for you know, similar acts or things that are. So I think we need a mental shift from all, you know, and all these actors could take a step back maybe and look at all the systemic reproduction and how their actions actually could reproduce some of these issues.
Yeah, and on that point, can I just add one little thing? And on that point, it's a subject that Marie and I have a lot, but we share a research interest in this subject, so that's why I'm excited. On that subject, for example, we've seen how the center of the court hasn't really worked, for example, to deal with the fact that there is systematic over-policing of racialized populations in Canada. And so courts have tried, you know, and you look at what the law of criminal procedure, and the law of criminal procedure says, you know, initially said, well, you know, if you're not under arrest, you're free to go, right? And so people who are in an encounter with the police are free to say, "Are you arresting me, officer?" And if the officer doesn't have reasonable and probable grounds to arrest, you can just go on your merry way. Well, that didn't reflect the reality of people who were being policed at all. In fact, the normativity that would be experienced by people who've been policed is if the police stop you, you better do what they say. And you know what? That was actually good wisdom, because if you didn't, the situation would escalate, the police would develop grounds to arrest you, and you'd become arrested anyway. And the courts, from their remove, would say, oh, no, 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 no. If there's no reasonable and probable grounds for arrest, a person is entitled simply to walk away. So then courts tried to recognize that problem, and they came in and they said, yeah, we recognize that sometimes people feel detained and are in fact detained. And so now we're going to say, no, police, you have a responsibility not to detain anyone unless you have reasonable grounds to suspect. It's a slightly lower standard because it's not an arrest, it's a detention. If you have reasonable grounds to suspect someone of a criminal offense, then you may detain them for a short period of time. Well, guess what? That didn't solve the problem either, because then police would continue with the practice, as they did in Ontario, of carding people, right? Simply stopping people and say, hey, can I see your ID? Person's not being detained, right? The police isn't doing anything to make the person feel technically detained. The courts didn't recognize that as a detention. Well, what happened? The state stepped in at the level of regulating police discretion and said, you know what? We're going to look at, and this is in response to complaints to the Human Rights Commission, we're going to look at this practice of carding, and we're going to find that this practice of carding can't continue, right? And to do that, that required some engagement with communities and police to do away with the sort of fictions that were operating at the level of the courts that these were not detentions that were taking place. Now, I don't know how well, some people have responded, well, this is still a state-based response. We still need to do away with the culture that perpetuates over-policing, and that's going to be something that can't take place within police forces. But the point is, what used to be discussed by courts that were handing down legal norms to police are now being developed much closer to the level of police themselves.
Thank you.
Yeah.
I'm just mindful that we're running out of time, and I want to make sure that we can also put a few questions from the audience. But I will ask one final question, which perhaps is a rather fundamental one. Why do people commit crimes? So we have a criminal justice system in order to address criminality. And one of the interesting questions is the assumption of moral choice. If we didn't believe in the idea that individuals have moral choice, criminal justice wouldn't really make much sense. And with advances in neuroscience, now one of the expressions which has emerged is the idea that I didn't do it, my brain made me do it. And neuroscience has, in many respects, fundamentally challenged the conceptions that we have about why people commit crime. So my question is whether this new understanding of criminal behavior should change our understanding of why it is that we punish criminal. And you, Alana, as a guest lecturer in my class on criminal law, spoke about mental disorders, the idea of mental incapacity. And in a sense, a mental disorder is a very wide spectrum, and perhaps the criminal law understandably limits the mental disorder defense to a very, very narrow range of crimes. But if one looks at questions of mental health in society, where there's a very significant proportion of the population, including members of the law faculty, myself included, who could fall into that spectrum in one way or the other, in the sense that mental disorder is simply one extreme on a spectrum. So the question I want you to explore, just before we open the floor to the audience, is, well, we look at treatment for mental disorder differently than punishment for crimes. Should we be blurring the distinction between treatment and punishment? Is rehabilitation, as one of the purposes of criminal punishment, one way of bridging that gap? So what are your thoughts? Maybe we begin with you,
well,
Maria.
I think that you've mentioned the work of neuroscience, and I think there's some really interesting literature that's emerging more and more. The work of Deno, for instance, in the US, that has looked at people who are being executed and has looked at some of the scans of their brains and did an extensive study that took several years, I think about 10 years, and looked at the actual brain of these individuals and realized that there's lesions in the brain, and so that pretty much re-questions, is this person a rational actor that will, that we need to punish, and the whole issue of moral blameworthiness here, are they, if it's, again, as you say, the brain made me do it, how do we take this, and what do we do with this information? I mean, the causes of these lesions could be very multiple, right? It could be environmental causes, socioeconomic contexts. It could be also genetic or severe alcoholism, and so there's a wide range of issues that exist. I think one of the ways to think about it is how can we improve conditions on the ground for certain populations. I think that's one of the main elements. And perhaps we might want to think about, treatment of certain individuals. But again, the line is blurred, and it's not always complex. It's not always that easy to delineate punishment versus, somebody who's been forced into into a therapy. And that's, sometimes the therapeutic angle takes a huge amount of time, and it's a lengthy process. So we have to, and it's again state-driven, and it's a state. The state uses its power to intern certain individuals. So it might resemble very much a punishment if we look at it through the lengthiness and also to the effect that it has on these individuals. So I think it's not an easy question, or it's to be aware of these realities and how maybe the criminal, maybe these are cases that maybe should not enter the criminal justice system, and we might think about other systems that might actually be more useful.
Okay, Alana, quickly before we open the floor for questions, if in the future neuroscience can predict with a reasonable degree of accuracy whether a particular lesion is going to give rise to a criminal conduct, should we be approaching criminal justice and criminal punishment from a totally different perspective of preventive therapy, preventive treatment, or is this a dystopian future or utopian future?
To me, preventive punishment and treatment is...
Preventive treatment.
Preventive treatment is a dystopian future. I think there's a really, if you look at, invoke Foucault, the ideas of, in fact, treatment and punishment have blurred, particularly for people with mental disorders, for a long time. I think there was a perception somehow that you might be able to treat people through punishment. I think that's something that is wholly unrealistic in the society that we live in now, that you should actually be able to treat people through criminal punishment. And in fact, there's been an increase, and again, this might have to do with something to do with the statistics and how we collect data, but increasingly, the estimates of the number of people who are in prisons with mental health issues, the proportion of people who are mentally ill in our prisons is increasing and increasing over time. Again, this might be in some ways a function of our willingness to recognize mental health issues that we've been less willing to recognize before. The criminal law itself has this very narrow conception of the kinds of mental health problems that might exonerate someone from criminal responsibility. But I think we're starting to recognize the role of mental health, and to me that's another thing that's kind of calling into question, in some ways, the capacity of our current model that's based on guilt or innocence, and this pivot point of guilt or innocence, at responding to those kinds of mental health issues.
Thank you.
Yeah.
Thank you. Well, we have some time now for questions from the audience.
Thank you. So this is a question on going back to retribution and vengeance as one of the purposes, supposed purposes of criminal law. In Professor Akhavan's Public International class today, we talked about the meaning of universalism and universal rights, and whether that idea of universalism was formed by consent or by sort of an outside moralism. And in Professor Klein's evidence class, we talked about the admissibility of evidence as to a victim's violent nature when you're dealing with a case of self-defense claims. So it seems culturally we seem to exonerate, maybe through consensus, the good guy who does bad. So Carl Lee from John Grisham's A Time to Kill, for example, or Dirty Harry. And we exonerate and sometimes actively support vengeance or retribution. So my question then is, how do we shift consensus, that is public consensus, practically as to the purpose and role of criminal justice? Thanks.
Marie?
Well, I think there's this the seeming consensus about what we're achieving or what we want to do. I wonder if there is, if it is actually a real consensus that exists. First of all, I think there's different views about what punishment is doing and whether it's vengeance or not. I think that also is contested in itself. You know, a lot of people might think that vengeance is actually a kind of unlimited way of punishing someone, very much emotionally driven. Again, if we take some of the proportionality theorists and just discern and ways to limit that, there's room for mitigation and there's room for actually looking at the moral blameworthiness of an individual. So I think it might be too quick to say that retribution is necessarily vengeance, and I think there may be other different conceptions that exist, and we need to be kind of attuned to these different versions and the plurality of visions that relate to that.
Any thoughts about that? Any other questions from the audience?
Thank you all for this fantastic talk. I had 3 questions, so one for both panelists and 2 individually. I think a theme that came up in the discussion is the reactive nature of the criminal law and how it's unable to address a systemic change or to manufacture systemic change. And I was wondering if the paradigm shift that you guys are talking about is necessarily always within criminal law, or if it exists outside in other avenues, as opposed to just recalibrating the system. And then specifically for Professor Klein, with your work with persons with HIV, decisions in Mabior and Courier, the SEC grapples with this concept of significant risk or bodily harm that may be caused to the person who the disease is transmitted to, but they don't particularly define what that significant risk is. And I was wondering if you could speak to the uncertainty with which the reactive nature of law caters towards the conceiving of guidelines with respect to people who operate in these kinds of environments and instructing persons with HIV and how they're supposed to act, because the decision seems to suggest that a low viral load and use of a condom could mitigate that significant risk, but it's unclear. And then Professor Manikis, I was wondering if you could maybe speak to the theory that was developed by Michelle Alexander, because there is a claim to say that there are systemic issues that the criminal law can address, but the stronger claim is perhaps that in the United States, for example, that Jim Crow has sort of been disguised as the criminal law, as a racial caste system. And I'm wondering if that stronger claim is just merely provocative or if there is some truth to it, and whether or not that theory is applicable in the Canadian context.
Okay, so I'll start with your question that was directed specifically to me. I think that the Supreme Court was relatively clear in the Courier and Mabior decisions that, at least on the state of science at the time when the decision was made, that the duty to disclose was triggered whenever there was, the court said, a realistic possibility of transmission, which is certainly a vague standard. And the court found that there was a realistic possibility of transmission in any circumstances other than those in which a condom was used. And there was also a low viral load, right? Now, there has been some research that has come out since that decision that suggests that the chance of transmission when the viral load is suppressed approaches 0, even according to scientists who have a very hard time saying things like approaches 0. And even within the scientific community, that's been the language, it approaches 0. We haven't necessarily seen that since then. And so I think, people had been asking for a kind of clarity from those decisions. I think at the very moment the decision came out, it offered a kind of clarity, but of course now there have been scientific developments that have revealed that the risks of transmission, even though, when viral load is suppressed, are very, very low, are even lower than were thought at the time when that decision came out. And that has made it difficult. And I think especially has engendered a kind of cynicism among the community of people living with HIV that even zero risk isn't going to be enough, right? Because as long as this was what many people felt, many advocates from that community felt, was even when there was a theoretical risk but not a practical risk, the court still found it appropriate to criminalize. And in a way, they viewed that as a kind of discrimination against people living with HIV, as I mentioned in some of my previous remarks. And so I think that people are afraid, right? I think people are afraid, and this is reflected among other marginalized communities as well, that no matter what the law is, it's always, people become cynical, always going to develop in such a way as to criminalize them in a discriminatory way. People have struggled at the community level to try to respond to those decisions, but those decisions are really felt in a way as a kind of discrimination. Yeah.
And I guess your question tackles, again, the issues of discriminations. I don't think, you know, I guess we can't really say that the system is there specifically to discriminate and does it in an intentional way. I mean, that's, it might be, you know, it might be going a bit too far in that sense. If there's, but one thing that it does really happen is that, you know, certain populations are overly represented. Again, the marginalized groups, and if you think about statistics, you know, we were saying indigenous populations, 28% of people incarcerated are indigenous, while forming only 4% of the population. And so you kind of get these questions: what is happening here? What is the processes behind that, and what are we trying to achieve? I think it's you know, there's a greater, and you know, some have argued that it is a tool that's used specifically to go against certain populations. You know, when you think about certain traditions that were criminally rejected and considered criminal, for example, Sundance or other traditions by indigenous people, and the way that the criminal law has had these effects on individuals, on removing questions of identity completely, and of also trying to remove cultural differences. I guess we are left with that you know, and I could see how people might come with that conclusion. You know, I think sometimes these phenomena are a bit more, I mean, I wouldn't say sometimes it's not even an intentional element. If you think about policing, or, you know, it's very hard to say that every single person who discriminates, you know, knows this, and they're, you know, if you ask most people, they don't even know what discrimination might be. So, so it is, maybe it's the way that, you know, trainings occur, or even what's going on in the greater society. Maybe that's where we need to address the issue, rather than specifically focusing on the process itself. So,
we have about 5 minutes left. Are there any other questions from the audience? Final questions? Yes?
So I have a question about what we were discussing with neuroscience, challenging conceptions of why people commit crimes, kind of related to that. So in my law and psychiatry class, we're talking about the possibility of bringing back the asylum as maybe an alternative to putting people in prison. But not the asylum as it used to be conceptualized, basically as like a segregating and dangerous institution, but as a safe haven for people who have mental illness in the criminal justice system. And so I'm wondering what you think about that, especially for people who might not fall within the narrow definition of not criminally responsible. Do you think that bringing back an asylum that is more of a safe haven might be an alternative way of dealing with mental illness in the criminal justice system?
Well, in fact, you know, this is sort of in part what, upon reflection, I would have liked to have answered in some ways to Payam's question, his question about utopia and dystopias, which was that I think that part of the reason why we see such overrepresentation of people with mental health issues in our prisons right now has to do with the lack of care that that people with mental illnesses have actually been receiving, and that's been decreasing over time as we've scaled back social services and withdrawn the welfare state. And so a lot of the time, people would never have committed offenses in the first place. It's one thing to say, well, it's their brain made them do it, but in fact, anything your brain ever does is a combination between your brain and the world that it engages with. And your brain is less likely to, quote unquote, make you do it if you, for example, have a home, a stable home, if you have food, if you have loving relationships, if you have a feeling of value and productivity in society. And so I think in a way, when you ask the question of, should we respond with preventive care, I think you have to take a lot of care to think about what that preventive care might look like. So preventive care that looks like a form of support that actually responds to people's needs, yes. Is the asylum going to be such a form of preventive care that responds to people's needs? Well, I think you would need to ask people with mental illness of various kinds that have been shown to contribute to increased rates of representation in the criminal justice system. I think you would need to ask those communities of people with mental health issues whether indeed such an asylum is something that's likely to work. Of course, you do that in consultation with experts as well, but I would suspect, in thinking about the mental illness that I see around me all the time, among friends, among family members, that that probably wouldn't be the first type of support that most people with mental health issues would be seeking. But they would probably be seeking support for the maintenance of the bonds that they do have, and for nurturing new close bonds with other people. So yeah, those are my thoughts on that.
Maria, you have the last word.
Just to pick up on that, I think, and it's entirely true that we've seen, in terms of statistics, the number of mental institutions and lower, and that's when the prison population has increased. So there's all over the world where there are prisons, we could see that trend in statistics. So it's interesting to think about this as an issue and to ensure that if we are to have more care in institutions, it doesn't become a punishment. And again, it's not a hidden way of basically reproducing what we do in criminal justice. So as Alana said, much more focus on the ground and the relationships, and as well and this could be reproduced in a community or in a setting that's far from a punitive model.
Well, thank you very much to both my colleagues, Maria and Alana, for their very rich and valuable comments. And unfortunately, this brings to an end this dialogue on perspectives on criminal justice and human rights. So thank you very much.